Hey, everybody. Welcome to the third episode of the IC911 Podcast. My name is Ted Walter. I'm the Executive Director of the International Center for 9/11 Justice. And I'm very happy to be joined today by my friend, Matt Campbell, who is the brother of Geoff Campbell, who perished on September 11, 2001 in the North Tower of the World Trade Center. Matt, it's good to see you. How you doing today?
Yeah, hi Ted. I'm doing all right. It's been a busy run up to what happened yesterday in court, and I'm sure we'll get into that. But at the moment, enjoying some rather strange, hot, decent weather in the UK, which is a bit of a shocker.
Nice. It's also quite hot here. I had to turn the AC off so people could hear me. So I might start getting a little hot during this, but hopefully we'll be okay. I think also a lot of our audience might recognize that you no longer have the horns on your head. How does it feel to be without horns of hair?
It's actually like having a really bad haircut when you sort of go, I don't like that haircut, but I've actually done it a bit more extreme and taken what little hair I had left. I mean, it's just hair; it will grow back.
You're going to go back to the horns, right? This was just for
the kids aren't too impressed. They just said I look like an old bald man. Yeah.
Well, you look just fine, but I actually have gotten used to the horns and I really like them. So I know they weird out some people, but I don't know. Those people are overly judgmental, I guess. I like them.
It was important for me yesterday. So, like I said, we're going to talk about obviously the hearing yesterday, but I didn't want to give any excuse for the judges not to take what we're doing seriously. So they had to kind of come off. It'd be silly to risk anything otherwise. So much time and effort and money has gone into this over the years.
Yeah. So the reason that we're here and that we're talking is that yesterday was a preliminary hearing in Matt's case against the Attorney General for England and Wales, who has denied the application that Matt's family made for a new inquest, or rather for permission to apply to the High Court for a new inquest into Geoff's death to be opened. And much of the audience will know, but a lot of people don't know that Matt has been fighting for this for the last 4 or 5 years, and really the last decade, because there was an original inquest held in 2013 for Geoff and 9 other British 9/11 victims. The inquest for all 10 victims took about an hour and a half, and I think a few minutes only was spent talking about Geoff and his life and his death. And the conclusion that the coroner at that inquest reached was that the impact of American Airlines Flight 11 led to the collapse of the North Tower at 10:28 a.m. and thus took Geoff's life. And I think, Matt, you were not present at that inquest, but pretty shortly thereafter, you realized that you wanted to question the findings of the conclusion of that inquest, and you started on this journey of trying to get a new inquest into Geoff's death. I don't know that we need to rehash the whole story, but why don't we just start from 2021 really briefly, because probably a lot of the audience knows, but just start from, say, 2021. What has happened to bring us to this point now?
Yeah, so we submitted the application to the Attorney General. I think it's 26th of August 2021, and it's a 2,500 page application. We had eyewitness testimony. We had letters of support from other 9/11 victim family members. We had expert testimony, and it was a very serious, well prepared. Took us about a year to prepare it. Application. And then they sat on it. I mean, they sat on it for nearly 2 years. And I think it was back in June 2023, they finally got back to us, and basically it was a flat out no, with only a few paragraphs even addressing reasons why they've said no. We weren't happy then. We, at the time, knew the only way to challenge that was potentially through something called judicial review, which way you get the courts to look at a decision that had been made to see if it was a lawful one. We threatened judicial review by, here's our skeleton argument, our grounds rather, and you've got a small window to either go and fight us or withdraw their decision. So they withdrew their decision, which was a small victory. But then 4 months later, they reconsidered their decision and came back with another notice. This is January 2024 now. And that is the decision that we are trying to challenge in the courts. And it's, like I said, it's this process called judicial review. And I guess where we were at yesterday is we're in this peculiar situation where the Attorney General is essentially trying to say that they're above the law and their decisions, in this particular case to do with reopening an inquest, can't be challenged by the courts. And so the judge that looked at our application, which was submitted, October last year, decided that it was better to separate I guess we call it the judicial review process, with this one-day preliminary issue hearing on only the issue of basically, is the Attorney General amenable to judicial review? Can the courts interfere? Which is frustratingly so far away from where I want to be, which is getting my brother's inquest reopened. But it's one of those things, lawfare, the way it works, it's just hurdles put in front of us. And so yesterday was basically about we were represented by Nicholas Bowen, who's a KC, and Nick Stanage, who's a barrister who's been with me for ages.
What's the KC, by the way?
King's Counsel. It's the most senior sort of lawyer, if you want to call it that, in the UK. And we were against Sir James Eadie, who was a KC, who was representing the Attorney General's office. And essentially, what we were trying to do was put forward a case as to why the Attorney General shouldn't have this so-called superpower that makes them immune to any sort of judicial oversight. And that was the purpose of the hearing. We can go through a little bit of what went on, but I don't know if you've got any questions at this stage, Ted.
Yeah, a couple of questions. First thing I do want to clarify, so everybody knows, is the specific part of the coroner's conclusion from 2013 that you're challenging is specifically what brought down the building. What was the proximate cause of Geoff's death? Just to be very clear about that. There's other parts of that conclusion that you could possibly challenge. I think they said, flown by Al-Qaeda terrorists and whatever, but that's really, at least right now, in terms of making the case for a new inquest, that's the only thing that you were challenging, is that conclusion.
Yeah.
And I think, we could get into also what about the Attorney General's decision, but we can get there. What about the Attorney General's decision is so, I think, abhorrent and really, in my view, is unlawful and does not go by the test that is supposed to be used for whether a new inquest should be opened. But why don't we just, on the question of, the preliminary hearing and the so-called justiciability of this, or whether or not the Attorney General is subject to judicial review. Obviously I've been involved in this and I've read the skeleton arguments of both sides. The skeleton argument is like a legal brief, submitted by either side, we have Grok or ChatGPT analyze the arguments, and they say, oh, you have an 80 to 90% chance of winning. So I think you came away with a different feeling yesterday. We don't want to get into prognosticating too much or like going into detail about kind of what we think is in the mind of each judge. And there were two judges. We should clarify that as well. But I just want to, I guess my big question is like, just big picture. How do you feel? How optimistic or pessimistic do you feel? Keeping in mind that it feels like the law is completely on our side, and that the courts want to, in general, move towards saying that the Attorney General should not be totally immune, and yet things were more complicated than that yesterday. So, what was your big takeaway, and how you feel now?
Obviously I'm not a legal expert. I've learned an awful lot about law that I never thought I'd have to ever look at. But I think, just in terms of how the day unfolded, I was surprised and pleased. Essentially, we were given a fair crack at the whip. The judges, both of them pretty much to different extents, just treated this, I guess, like a normal case. Yes, everyone acknowledged that there's a wider, bigger picture about what I'm trying to challenge, or the end result, if we get there, of what we're trying to do. But essentially, it was kept to the narrow frame of this justiciability. Is the Attorney General amenable to judicial review? And so, yeah, I felt that it was fair. The judge, both of them were asking questions. So just to give you an idea, basically, at the morning session, we had our ability to go through not only our skeleton argument, but Nicholas Bowen, the KC, had prepared like a 50-page notes that he called them, where obviously he's referencing stuff that's in the skeleton argument, but he's also other bits and bobs that he decided to bring in. And there was some interaction between the judge asking questions, and it was interactive, and it seemed a fair process to me. And I felt that we did really, really well. I mean, Nicholas, is definitely worth his money in terms of the way that he carried himself, conducted the debate, I guess, between himself and the judges. And then in the afternoon, the KC for the Attorney General's office had his turn to respond. Spent less time, probably because he had less, I think, things to say in his defence. But anyway, it was a shorter period. And then we actually had an opportunity to go back to some things that needed to be covered in a bit more detail, but we actually able to almost summarise the case. And I think, it's very hard. You're trying to read the body language of the judges, and I said I don't really know how that went, but essentially, as we concluded the day, I felt it had definitely gone better than I thought it would have done. You go in there with some optimism and hope, but you don't really know. I've never been in this situation before. A decision wasn't made, so I can't tell you whether my optimism is well placed or I should be preparing for the worst. We don't know. We think it's probably going to take at minimum 2 to 3 weeks to get a decision. We can go into it's a little bit complicated, I think, because there's 2 judges and not just one, but that's because it was a complex area of, I guess, constitutional law that we were trying to attack or dealing with. But my overall sense was, I'm positive, but I'm also a bit of a realist. What we're trying to do is not easy. For that's historical reasons. I think the judiciary has always shied away from interfering with decisions of government, or particularly the Attorney General. Historically, that's just the way it's been. And even though we've seen in recent years people getting closer and closer to changing that, which is obviously what we're trying to do, very much so. It was not going to be an easy victory at all. So we've gone in there going, "Oh, we're going to win." I'm like I said, I think we had a fair crack at it. I got the impression that one of the judges was pretty much on side with what we're trying to achieve here. Mm-hmm. Certainly, he seems to be a bit more, let's say, progressive as a judge in reinterpreting or looking back at law that in the past and adopting it for a more modern era. And the other judge, perhaps a little bit, I don't see him perhaps being persuaded as easily. But you never really know. You mentioned shoving it through ChatGPT and other AI engines in terms of on paper what's our chance. And 80 to 85% I think was pretty much what they came back with. But that's in the cold light of day without actually factoring in there is some real human stuff going on here, egos, power struggles, whatever. Without getting into any deep state shenanigans, it's probably not that anywhere near that favourable. I think most recently, up until certainly yesterday, both Nicks have always said our chances are probably 50%. Just the nature of how this can go. It really is one way or the other, and it's just a matter of is the time right? Is it, I guess, almost without saying it, is it politically the correct time? And you look back historically at things like Hillsborough and Bloody Sunday and stuff. It took a long time, but only when it was right did they actually achieve what they were trying to campaign for all those years. So, optimistic, but at the same time, we know that they, you get obstacles put in front of you every time you try to do this sort of stuff. So I'm expecting the worst, but hoping for the best.
Yeah. Okay. Well, not that you're a legal scholar or anything like that, but just based on everything you've been learning in the past couple of years and what you heard yesterday, like kind of in a nutshell, like what is more or less the path to the court deciding that the attorney general is subject to judicial review, and then kind of like what's the most viable path to them deciding that they're not? Because I got the impression from what you said about the hearing yesterday that this precedent of Gourier, which was this decision in 1978, that really got attacked. And perhaps if the court is going to go in the other direction and say that the attorney general is not subject to judicial review, it might not be based on Gourier so much as more of this like tradition and like historical kind of, as you were saying, going back, even centuries. So what is like the most likely path in either direction? How do you make the case either way?
Yeah, well, God, that's a hard question. I mean, certainly just touching on the, the law. I mean, we were digging in law that was, 1902 and then some 19th century law, which there's some small submissions we've got to do by Friday, which almost certainly is going back that sort of length of time, which is, quite astonishing. But, I guess that's how law is built on. It's layered up. And so you do sometimes need to go back to understand fully why something's in place 100 years later. Yeah, I mean, in terms of us being successful, because we've got two judges, my understanding is we really need both of them to agree that, essentially the Attorney General should be subject to, should be amenable to judicial review. Like I said, I think that's probably a bit optimistic, but, if that were to be the case, the Attorney General would certainly have the ability to appeal that. It all depends on how strongly they put it in our favour, because if it looks like there's no way they can possibly appeal, they probably wouldn't want to go and challenge it in a higher court, be it Court of Appeal or even Supreme Court. It's almost just take their medicine and just decide that, okay, enough's enough, we're going to lose this. Them finding that they still aren't amenable to judicial review, which, is probably what's going to happen, but we don't know for sure. We have several ways in which we can still win. So, I think a simple scenario would be we lose, whether it be 1-1, but there's still, our foot's in the door. They give us reason why we should be able to apply. Because I think
Yeah, and I just want to be crystal clear for everybody. If it is for you to prevail at this stage, it needs to be 2-0. You need a complete majority. If it's 1-1, it's basically split, and you don't have a majority, and the claim actually fails. And as Matt, as you said before, they assign 2 or sometimes even 3 judges when there's a case that is either very complex, but also I think like of real constitutional importance. So clearly they viewed this case as kind of potentially laying down very important precedent about whether or not the Attorney General is judicially reviewable. So yeah, if only one judge is with you, it's a split decision, but that could make the path forward a little bit easier.
That, as I understand it, I mean, obviously not an expert on this, but my understanding, just asking the question yesterday, is that almost automatically gives you the right to do a Court of Appeal, route, which makes perfect sense. That you still have to probably go through the process of applying, but it should just be granted. Yeah. One other path, which is probably interesting, purely because it'll be a quicker decision, and certainly won't enable any counter appeals should we win on appeal, would be going directly from losing, but the judge basically accepting that, okay, this is a very complex area of law, and we're going to go and issue what's called, I think, a certificate under Section 1 of the Justice Act, where you go straight to the Supreme Court, which is the highest court in the land, and a decision would be made there on this issue of justiciability. Yeah, I mean, again, we don't know. We don't know how the vote's going to go, and there probably are some more options and paths, but it does get a little bit complicated and hazy, to be honest. But I mean, so win or lose, I don't think it's the end of the road, because we certainly have the ability to go down the Court of Appeal, where you do have 3 judges, which you'll definitely get a result in a Court of Appeal. Obviously, that could be 3-0 or 2-1. And yeah, so I'm probably, in terms of where I'm at and where my mood is, I'm kind of just knowing that, okay, there's still some fight ahead. Even if we win this, if we lose, potentially, if we fast track the Supreme Court, it would be great, because it's certainly less money, less time being wasted at a Court of Appeal if you're then going to just pop it up to the Supreme Court in the first place.
And so, what would be the basis for them, for both judges, or even the more conservative judge, to say, like, would they essentially be saying the Attorney General is always immune from judicial review when making all decisions, and therefore, essentially they have no accountability and they can do everything based on discretion? Is that what the outcome would be? And what is the basis for that?
Well, I mean, interestingly enough, I mean, as we went through the hearing yesterday, because Gurrier is a peculiar case, it's what's called a relator action, which is the judge, basically stated that our case is not a relator action. And it was kind of conceded by the other side that, okay, Gurrier is essentially a relator action, even though they try to say, yeah, but the underlying principle is the same. It applies to other things, other functions that the Attorney General has. So we did actually discuss the functions of the Attorney General as a big, long list of things that they do. But no, I mean, essentially, this ruling on whether they are amenable to judicial review or not would only be limited to inquests. So, i.e., Section 13 of the Coroner's Act. So it's quite narrow in scope. And if you, one of the things we did was we went through all the long lists of all the functions that the AG has. They are distinct, and it really, because it's an area of statute law, it's quite low down in all the weird things that the Attorney General can do. And so they could actually not have this superpower at the inquest level. I mean, they openly talked about the function of gatekeeper, which is what they are. And I kind of get that, because the court doesn't want to be flooded with nothing that's been screened out, etc. But that's fine. Their function as gatekeeper, I get it. But you should be able to challenge. It makes no sense in this day and age. And that was, brought home a lot, that we've got to move on from the days of kings ruling and having absolute discretion and power, which is what the Attorney General's after.
I mean, it's the Attorney General in this particular situation is supposed to be a gatekeeper, a filtering device, to screen basically totally, ridiculous applications, and so they don't have to go before the court and kind of waste the court's time.
And I think that's accepted. That is one of their functions. Yeah.
Now, we all know in reality, courts also make decisions based on political considerations. Like there's every court. Some people say that, like, courts are just politics by another means. Okay, putting that aside, in this particular situation, the Attorney General is just supposed to be performing like a legal function, which is to objectively analyze, according to the law, according to whether the court would actually grant this request. So it's hard for me to see how you can construe that as being like a political function, or a matter of sort of prosecutorial discretion or what have you. But
I mean, the AG was actually, or the case he for the Attorney General was almost arguing that there isn't any standard that's actually written in statute that they have to meet when making a decision. They can almost just turn and go, nope, that's it.
Well, I was wondering that. I mean,
they're arguing for essentially was, we argued that that's a ridiculous situation, that they can just go, no thanks, not give any reason.
Yeah, I mean, I always have wondered in the back of my mind, like, where does it say, or where does it come from that the Attorney General is actually supposed to kind of go through the same legal test process that the courts would in deciding whether this inquest should be reopened? And I guess the idea is that they are sort of simulating or predicting how the court would look at it, and deciding. And like, that's kind of, is that not, I mean, how strong do you feel like the counter argument was that they should have to be actually doing a legal analysis of the application, and that they're
It was, we didn't, I don't think we really counted that, because it was they'd got to the point where everything was just underlying principles. Because I mean, we basically, both sides, neither side could find any precedent case where it actually states that for something like an inquest application, they are immune to judicial review, because conceded that Gurrier is a different class, a different case compared to my case. Which I find bizarre, either for or against. There's no, either way, it's not been set. There's no precedent. We look back actually at coronal law from when it was first put in place. I think it was like in the mid, probably 19th century, where I think it's lack of police or something. They just basically set up this idea of a coroner to do these inquests. And we looked at why it was set up and what powers the AG was supposed to have had. And then when it was updated again in 88, again, you know, where does it actually say an awful lot of stuff that both they rely on and we rely on? And actually, it's kind of weird. There's not a lot there. And so, oddly enough, if they make a ruling here in our favour, it's actually potentially going to be the first case where a ruling is made on whether they're judicially reviewable or not. Okay, it's not in a higher court. So a lot of the discussion yesterday was whether stuff was in the Court of Appeal or done in the Supreme Court, but certainly the Court of Appeal, which is a higher court than the High Court.
Yeah.
And so stuff tends to be binding if it's a higher court or in a lower court dealing with it. We don't really have the authority or the ability to do it. But we're not actually trying to turn anything over here. We're actually almost trying to set a precedent, because as we found out, there's not really anything wise that actually nails.
And like, you could interpret Gurrier, the 1978 decision that supposedly created this precedent. You could interpret Gurrier pretty narrowly. And I think that's my sense of what happened yesterday, was that Gurrier was quite undermined. And if you're interpreting Gurrier narrowly, you're not overturning the precedent of Gurrier. You're just saying, well, that applies to, you know, relator actions or to that particular type of situation, but it didn't apply to anything else. And it was mistaken for people to always assume that it did. So we're just creating new law here. We're not like overturning something per se from the past.
No, that's very true. And I said going back in time. So the Gurrier case relied on a LLC case from 1902. And again, you go into the weeds. It's like it's only about relator action, which is essentially you don't have standing. You're trying to get the Attorney General to do something on someone else's behalf in the public interest. It's got nothing to do with what we're trying to do, you know, through the inquest mechanism. So, I mean, honestly, it was kind of just mind blowing hearing things like that, because you've always assumed that at least Gurrier would be the binding thing, and it doesn't appear like it is. So who knows how this is going to go? I just, like I said, I think we had a fair crack at the whip, and to me, you know, it's just going to be a case of, okay, which way is the time right now for them to decide? Actually, we do need to have some judicial oversight of this peculiar situation that, you know, the Attorney General for England and Wales has basically, and we talked about it openly, a superpower.
Yeah,
completely immune. It's ridiculous, absolutely ridiculous. You know, and Nicholas Bowen, you know, frequently used that phrase, which it cropped up in a previous ruling. It'd be a very unattractive position for the Attorney General to maintain that superpower and be able to do things basically unlawfully and get away with it. It's, you know.
Yeah, and I don't want to bore people with any details here, but I'm just like, why would that be an attractive proposition to a more, let's say, conservative minded judge? Do they actually like that principle, or is it just that they don't like allowing the law to change over time? Like, what is the gravitational pull towards wanting to have the Attorney General be totally immune?
That's a good question. I don't know. I said just historically, that's the way it's been. And I said, I mean, they talked about, forgive me, I can't remember, there's a Latin phrase for essentially forbidden area, forbidden territory. Yeah. Which is something like, say, for example, it was national security or some global political reason why you couldn't do, the Attorney General couldn't do something. They are within their rights and to actually say, no, you can't have your inquest reopened because of this forbidden area. Yeah. Which sounds crazy, but but that is kind of accepted that there are cases where the Attorney General can do that. But of course, they didn't do this in their denial in the decision they made in January 2024. So that wasn't the reason, or not a reason that they would publicly say why they are refusing us to get the inquest reopened.
Yeah. Yeah. Well, just I just want to point out you were there with your mom. Let me show a photo of you guys outside the courtroom afterwards. That's very sweet. Your mom's name is Maureen. Maureen. Sorry.
Yeah.
And this weekend is her 80th birthday. Is that correct?
Yeah. It's probably a strange way to celebrate in the days leading up to it, but I mean, I was glad she was there, and she was very glad that she made the trip up to London, if only to see me in a suit again. I've not worn a suit for ages, and with my haircut as well.
Yeah. That's not the Matt Campbell that I know there in that picture, but
it was good to go into that into the court. There's lots and lots of courts there, and in your head you almost assume that there's the Court of Appeal is a separate physical building. It's not. So in the court next door to us, there's got like I think 200 rooms or 200 courts or something. So it has lots of different things that they I guess take on there. And the court next door was dealing with a Court of Appeal matter. So I'm pretty sure all the stuff bar supreme will be held at the High Court wherever this goes. And
you talked about just being kind of blown away by how grueling it was and how much information and they had packed in their heads and how they had to think on their feet. Like, what was just the feel and the dynamic like of being in the courtroom listening to the lawyers argue?
Yeah, I mean, it was fast. I mean, it wasn't to and fro because basically they had their ability to just speak freely to the judges. But Nicholas Bowen spoke for just over 2.5 hours. Nonstop, without a break. He's almost losing his voice because he's not been feeling great. And it's you're dealing with questions from the judge. You are reading from his notes. He had a 50-page of notes to go through, referencing the skeleton argument. Whilst he's doing this, he's constantly saying, I draw your attention to, electronic bundle, whatever it is, page something, section EF. They're then talking, about great depth of whatever that court, whatever that related to, might be a previous case, etc. And then their judges asking for stuff, and they're having to flip backwards and forwards with, wherever the law is, bits of law that they're referring to. But what impressed me as well was actually, this is all compressed in. It felt very compressed. I've always thought, why do they only do 2 hours in the morning, 2 hours in the afternoon? I think it's because it's too intense. And I was impressed with the fact that, the judges a couple of times both said, take it as given that we have read all your submitted essential reading, from both parties. And that became clear as they were going through it, because they were calling references to things. It's like, oh God, their ability to recall what they've read with what's being presented to them in real time was, as I said, it felt fair. Yeah. And it wasn't like they hadn't read anything. It became obvious that they properly have looked at what we have submitted, obviously, as well as what the Attorney General submitted. But yeah, it was overall, it was it was a good experience, I'd say, until of course we get the judgment.
Yeah. Which will be in a
couple of weeks' time.
Which we expect will be in within, I think, a couple of weeks, 2 or 3 weeks.
My understanding is that because of certainly one of the judges, he tends to do stuff quite quickly. We're not expecting the potential sort of 6 to 8 weeks for a ruling, because there's 2 of them. It might take a bit longer. I really don't know. But my counsel basically advised probably 2 to 3 weeks. So count that from this Friday, because we've got some stuff to submit by tomorrow. So yeah, talking kind of 3 weeks 3 weeks tomorrow, we'd expect to have heard by.
Yeah. Well, just zooming out, I've for a while, I've been really kind of amazed and impressed by your demeanor in all of this, being so kind of cool and relaxed when this is really an incredible injustice on every possible level, that you and your family are going through. I mean, it's absolutely absurd that the attorney general's decision, the cursory, superficial response to all the 2,500 pages of evidence that you submitted. I think the abuse of their position as a gatekeeper. I mean, it's really, to me, it's almost cruel. It's cruel, and it's unjust, and it's like the epitome of like not having the rule of law. And so I'm amazed by your calm through all this. Is there anything, just kind of reflecting on the bigger picture, that you want to say? Or
I mean, touching on how long it's taken. I mean, it does astound me that it's taken so long. But I mean, even the first inquest took 9 years from when they adjourned it. And obviously 12 years on from 9/11. I've always known it's going to be a long process, and I know that I'm in it for the long haul. As long as I'm still got fight in me and able to raise the necessary funds to keep fighting, I'll keep doing this. I think just a little reflection on some of the things that my KC said in court yesterday. I mean, I think he was talking about the time from when we submitted the application in 2021 through to nearly 2 years later getting the first decision, which was obviously a negative one. He just mused out loud, going, for reasons not I can't fathom, but I have no insight or understanding as to why it took nearly 2 years to come back with that very terse no. And a bit later on, he kind of just mused again about it. Our case is so clear that we should have had the inquest reopened. He's almost musing out loud as to why it doesn't make any sense what's going on that we don't know about with the Attorney General for them not to just let this go through. And so, I mean, I'm going to keep fighting. I am frustrated. It's taking a long time, but I've just had to accept that. Ever since we did that first application in, then just kept waiting and waiting and waiting. I know this isn't going to be a quick process, but hopefully, because of the way one of the judges work, we're actually going to get a quick decision on this, which will be good, because then that will set whatever the next phase is, whatever we have to do. I'd rather know about it sooner rather than later. I don't want to be waiting for a year,
So, a quick decision for a change.
Yeah. And maybe that will be the case because the judiciary are involved and it's not a government sprawling, whatever they keep sending stuff out for. So, yeah.
Okay. Well, good. Thank you very much. It's always a pleasure to talk to you. And, fingers crossed, I will be thinking about this nonstop for the next, 2 or 3 weeks. Just wish you and your family all the best. So, and happy birthday to your mom.
Cheers. Thank you.
And thanks everybody for tuning in and for supporting the Campbell family. Many hundreds, even thousands of people have supported them over the last few years. So thank you very much.
Big thanks.